Yes. Madam, the date is showing. Put in February.
802.
802.
Your Lordships,
My lords, in 802, my lords, I seek your indulgence. In fact, we had mentioned this a few weeks ago. My lords, this regarding an environmental clearance given in Chhattisgarh, my lords, the felling of trees has already begun. My lords, I was not able to bring on record the photographs. It's a little urgent, my lords. In fact, my lords, when you had issued...
You are felling the trees now.
Yes.
Your Lordships, if I may just point out one thing.
The felling has started.
Your Lordships, on 27 November, my learned friend had mentioned this matter, and that time your Lordships had asked if there is an IA. Then your Lordships had directed the matter to be, there's an order on 27 November, listing the matter on 12th of February. Thereafter, there is an IA which has been made by my learned friend. I have been on instruction saying, your Lordships, I am for Rajasthan Raj Vidyut Utpadan Nigam Limited. There is a same matter filed by the same party before the NGT coming up on the 16th of December.
My lords, that's for the forest clearance. It's a different statutory process. My lords, I request you. My lords, the notice had been issued.
Already we have given the date on February.
My lords, if I could... My lords, a notice has been issued even there. My lords may remember.
February.
My lords, just the IA for direction. My lords, just the IA for directions, not the main appeal, my lords, because...
We know that, but you also missed it long time back. He said if I apply itself.
My lords, the notice was issued in May. My lords, my lords will remember, Mr. C.U. Singh had appeared. My lords, there is the main issue. My lords, the patent error is that the NGT orders are almost similar. My lords will remember that.
We remember.
My lords, if my lords would list the IA in January, the main appeal, my lords, may not come up. But if the IA for directions may be listed in January, my lords, early.
Very well, January.
The limitation is 740 days.
My lords, that's the main appeal. My lords, this is just an IA for directions.
You reserve it in January, yes, all right.
Very grateful.
803, you give it in February. Yes.
My lords, the notice has been issued in this matter on January 2024 itself, my lords.
That's correct, we are giving a date, yes.
804.
May I please?
804.
Plus, this is...
Sir, may please, any specific date may be fixed?
Yes. Yes,
804. My lord, this is appeal against conviction, my lord. My lord, I have undergone already 6 years, 10 months actual sentence, my lord. My lord, no date is showing, my lord. If my lord may list it before vacation, my lord.
Have you filed any application for suspension of sentence?
Yes, my lord.
Where is the application? Where is the application? Not here.
My lord, the application.
So give the number. If the application is there, put it next week. Otherwise, don't put a selfie. Application is there. Yes.
Great, my lord.
Item 805. It's already listed, Lordship. Tomorrow.
More space already.
806.
806, my lords, the date is shown 19th of December. I am seeking not to be delayed. Not to be delayed. This is a bail petition, my lords.
All right. Next week, please. February.
808.
Lord, but I'm mentioning Lord IA, Lord said directly to be listed on 3 week Lords. It was listed on 9th, Lords. However, Lords,
What is the year for?
IA seeking direction, Lords. This is a sealing matter, Lords. This is a sealing matter, Lords.
Sealing.
So, as per the impugn order, this is returnable land, Lords. I am seeking even as per the impugn
Land
order.
sealing.
Land sealing, Lords.
Put in February.
Lords, there is quite urgency, Lords.
What did you say? So you got a land back.
No, there is just returnable land as per the impugn order, Lords. I have challenged the impugn order, Lords.
That's correct, but you say you want urgency in this. All right,
Lords, kindly,
we are giving that date, yes.
second week of January, Lords.
Yes,
January,
yes.
811.
809, my lords.
Which one?
811 is connected with 808.
Yes.
809.
My lords, 809, we are for the respondents. It's regarding to the suit of partition, my lords, by the sisters. And the matter is not being listed from a very long time.
Last week of February.
Item 810.
810. Cancel petition next week.
812.
812. What's the 19th?
Some matters were listed yesterday.
March.
My lord, I'm requesting another matter is coming up tomorrow. If they can be taken up together, it's a matrimonial issue. Some quietus can be given to it.
We can't do it tomorrow. It could have been secretary earlier also. We can't do it now. You see, this would have been out by this time.
Can then be it in the next week, my lords?
But we can't do it, we can do it piecemeal, we'll put it in first week of March.
Item 813.
My lords, please. My lords, all the appellants in the matter of
Civil
more
appeal.
than... Please, my lords.
Yeah, March.
My lords, when I mentioned one matter which was part heard last week, my lords were hearing the Telangana Miapur lands, the land
Yes.
grabbing. My lords had kept it as part heard yesterday, my lords.
Yes.
Because the bench could not convene. My lords have
Come
requested
tomorrow.
for a day.
Come tomorrow.
Tomorrow.
Tomorrow, my lords.
Your lordship's kind permission may mention, lordship, 116 regular had been kept for today, but it's not showing in the list, my lords.
Not
It's a
possible.
part heard.
It-
Lordship may give a fixed date, that's all I'm not asking today.
The bench being made by the learned counsel for the
Just,
Please wait.
Please wait. 1 minute.
My lords, this will now lose its seniority and will go back again.
We can't help it, that's
My
why.
lordship may give a fixed date.
No,
Lordship
no,
may-
we can't give it, give a circular letter, we'll see about.
Lordship's
We can't
permission.
give
It's a part heard matter.
City council, but you see, this circular is there, we have to go by it. No, see, any direction the raising of the chief, we have to go by that. We can't bypass it.
I'm
We'll
seek-
take it up, no
I'm
problem.
seeking your
Just circular letter, we'll take it.
mentioning that has just been made for lordship. Procedure hasn't been followed. This is a regular hearing matter. As my
What procedure has not been followed?
as per the latest circular dated 29 November.
No, yesterday we were not there. Yesterday, there are two cases. I have requested her to list them today. One of them is listed today, the other one will be listed tomorrow.
My lords, a fixed
I'm
date
sorry.
matter.
Will your lordship's permission?
Please don't try to avoid the court.
Your lordships were not right.
No, please don't do that. Please don't do that.
With your lordship's permission, I would like to circulate an adjournment letter in a matter coming up tomorrow. It was originally for Tuesday.
What is the item?
Your lordship, it's item 20 listed
No, but
tomorrow.
tomorrow mention, we'll take that.
No,
May I
lordship,
please mention-
I still have time to move a letter of adjournment. It's a mentioning matter, so they will not accept my
No,
adjournment
no
slip.
problem, we'll give you, we'll consider it tomorrow, when the matter is taken, we'll mention, we'll accommodate. You want to accommodate?
Yes, your lordship.
Don't bother.
My lords, may I please...
So, what is required procedurally, and we'll accommodate, no problem.
Much obliged.
My lords,
After
may I
clearing
please
the other side.
mention, item 103, my lords, it is listed today. My lords, I'm praying for short accommodation.
Please mention all the matters mentioned and reaches.
May I mention item?
It, see, there are two parted matters, depending upon then, we'll take it up, we'll just find out how it goes on. Yes.
May I mention 110 list?
Please, same thing. It may not even reach, we'll have to see about it. If it doesn't reach today,
The difficulty, my lords, the arguing counsel and the instructing counsel were supposed to come from Bangalore.
Don't-
You may kindly have it next month. my
don't
lord.
bother, we'll accommodate when it,
Okay.
when it reaches mentioned.
Your lordship saying about 107, I'll mention when it reaches.
Please, ma'am. My lord, this is the transportation on behalf of the wife from Patna to Delhi, my lord.
Yes,
And the DV petition is already pending in Delhi, my lord. In
Yes.
20 courts.
yes, who's for said?
Distance is,
Yes, ordered.
My lords, I am appearing on behalf of the respondent, my lord. The only
Listen,
ground. my lord,
item
is-
number-
Yes, one minute, item one, yes.
My lord,
Yes,
my
Mr.
lord,
Chaudhary,
the
yes.
only ground is that the petitioner is residing at Delhi, my lords. I have
Yes.
annexed her photographs in my counter that she is already there at Patna, my lords. Throughout the year, she is performing as an artist in stage shows at Patna. That's the only.
DV proceedings are
ground
pending
she
in
is.
Delhi.
yes, my lord.
Only a DV petition has been filed, and that too, my lords, in the entire paper book, she is not written on which date she moved to Delhi, on for what purpose she moved to Delhi, my lords.
That's irrelevant, we already.
My lords may refer them to mediation, my lords, for once, my lords, that would, this is an
In the
SCLC
lower
matter,
court
my
itself,
lords.
if the proceedings are going on.
Already,
we
he's
are
not interested in audit, please.
obliged.
Well, it's an item number 2, I'm for petitioner
I'm
wife.
for respondent, I may be given some time to file a counter affidavit, There are, certain things which have been falsely submitted by the petitioner,
What is it?
There are certain things which have been falsely submitted by the petitioner.
What is it?
There are certain things which have been falsely submitted by the petitioner.
Her daughter, 3 years old.
Yeah, no, no,
Kindly see, she also
Well,
has a
sir-
residence in the Bihar also.
So one side is 1900 kilometers distance and 30 hours, my lords.
Maybe that is solution for pronouncing.
Already, 2 weeks for counter. Your date in January.
Obliged, my lord.
Yes.
Service on to service
Yes.
company.
Item
Yes.
Your lordship, I am appearing on behalf of the petitioner wife.
Yes,
This is a
yes.
transfer petition.
Matter may be transferred, my lords, but give me liberty to appear from BC.
Yes, all right. Item 4.
Obliged.
This is an anticipatory bail, my lords, that granted me interim protection.
Your Lordship need some time to file the counter.
What time is required? See, the allegation is that he has produced a fake document. The Public Service Commission has already debarred him for 3 years. So that sentence is already there. You want to send him to jail also?
Leave granted, in as much as the appellant has joined the investigation and considering the nature of allegation. Yes.
The petitioner has been custody for last 15 months.
Item 5. Yes.
He has been in custody for last 15.
Yes.
Because the main accused are absconding.
Main accused are absconding, and he has been arrested from Lucknow.
Okay, leave granted. Though the objection has been made, raised that main accused is still absconding. Fact remains the petitioner, the appellant has been in incarceration for 1 year.
15 months.
1 year and 15 months.
Similar 15 months. 1 year, 3 months.
And what is the stage?
Because the evidence is started. 3 witnesses.
And the trial has already begun, considering about it. Status of case.
Some strict condition may be imposed.
That will be trial court with.
And DPO language.
Yes.
So should say I am in custody for.
My lords, he has surrendered. He had gotten an interim bail. My lords, item number 6, 17 and 19 are together. Pleadings are yet to be completed. My lordships may have it on Thursday or Friday. I'll complete the pleadings and we can argue it out.
First. We will just take next.
Please, Lordships.
Next.
Much lordships.
I should say then.
Yes.
My lords, may I please? My lord, I wish to withdraw this petition, my lords.
Yes, member to withdraw, yes.
Obliged.
Grateful. Lordships may only allow me to mark my paper.
That's item 8.
Which one? Item 7.
Your name is there. Yes.
Item 8, that is the custodial death case, my lords, whether it's 304 part 2 or 302.
Yes, yes.
Subject to the convenience of my lords, may the matter be at 2 p.m. Learned senior is on his legs in bail matter.
No. We'll pass it over. After the miscellaneous matter is over, we'll take it up. We'll pass it over.
Deeply grateful. Lords.
May it please, Lord, the petition.
Yes.
Yeah, my lord, I'm told.
Please go ahead.
Yes.
They don't want to file a reply, my lord, in one.
The matter is a question of law only. My lord, 30 years he's been in custody. My lord, may hear it.
We'll hear it. We'll put it on non-miscellaneous day.
Please.
Or you can't leave and give a specific date.
My lord, we give a specific date because this will not take.
Leave granted. Put it in April.
In the meantime, my lord, April will be too long, my lord. He's also.
March.
In the meantime, we'll complete the readings.
The latest is making a request, at least we have to consider it.
So February, if you don't mind, sir. 30 years in jail.
That's all. We'll mail them. We are pleading to
Great.
complete that.
In the meantime, we'll complete readings.
Yes.
That may be.
Yes.
Pleadings will complete.
Yes, we said.
Item 10, my lords, appearing for the respondent private.
Item 10. Yes. Yes. Yes.
Well, it's a purely civil dispute.
Yes.
We are disputing the allegation.
Petitioner.
Please, my lord. Petition.
Yes.
Yes, please.
My lords, in this matter, my lords, if my lords may kindly see the FIR, the allegation in the matter.
It's a purely commercial transaction.
My lords, I'll just show one
In
allegation.
every commercial transaction, you can say that I have been cheated and all.
Not
How
in
much is
every
it?
commercial
Wait,
transaction, there's a fake
counsel,
GST number.
How much is the amount?
89 lakhs.
You refer to mediation, you pay some amount. Otherwise,
My lords, we already, as far as because there's two issues.
we'll refer to mediation.
We'll-
See, there is some dispute there. Otherwise, we'll consider on merit. All right. Parties are directed to appear on 24th December.
Let's appear for the state. Appearance may be rewarded.
Online.
My lords, maybe through VC, because my
VC only. VC.
my lords, one more, my lords may record my submission that we are disputing the entire amount.
Here specific case is that not only that you have changed the name and you have changed the DS number. It can go either way.
My lords.
Then you face the, then you
No,
face it. We are only trying to say, resolve it now. You owe some money, you resolve it, you will be a double botheration. You need not pay whatever they ask for. Negotiate and finish it off.
We'll appear in mediation.
Let's appear for the state. My appearance may be welcome.
In the meanwhile, my lords, may I file the counter affidavit as well?
You do that.
State of Gujarat respondent.
Deeply obliged, my lords.
Yes.
SUNDRESH, my lords.
What is this?
I'm led by Mr. Mukisefa.
We'll pass it over.
Pass.
My lords, I appeared for the respondent, my lords, if it can be kept for the next week, my lords.
Next week.
My lord, actually, my lord, in the first matter, my lord, the law has now been settled by this honorable court, and my lord, the parties have also actually settled between themselves. They've made an application, they've made a joint petition, my lord.
Already. Who is there for the first matter?
I appear for the state in both the matters, sir. Here the parties cannot settle because it's a Chika tenancy land and it's a government's land. IOC is settling it because the land doesn't belong.
They
to
never
them.
challenged it.
So they still require constitution.
All right.
Hearing.
All right. All right.
Well, so far as my matter is concerned, I appear in the second matter.
Yes.
And the High Court, if your lordship sees the judgment, it is only dismissed on the ground of maintainability. When there are two judgments in my favor covering the field. And the High Court has operated on the basis that Section 6 of the Section 8 of the Land Reforms Act will bar the jurisdiction of the court to interfere under Article 226. That's, my lords, completely wrong. So my matter hasn't been dealt with on merits at all.
Because in any event, my lord, if I may just, in one sentence, my lord, in any event, it is now settled by your lordship that it does not vest in the state if the structure in question is a pakka structure. Now, petrol pumps, my lord, by definition are pakka structures. There are, my lord, specific judgments to that effect, all upheld now by your lordships, my lord.
Right, we'll hear it. We'll hear it. Already putting a non-miscellaneous paper in February. Yes.
Well, I am for the petitioner.
Yes.
Item 12, my lord.
Yes. Yes.
But arises under the Estate Abolition Act, my lord.
70 years delay now. What can we do? It can't be in eternity.
No, my lord, as far as this case is concerned,
yes,
possession is with me, my lord, protected under the
that
Act.
we are not concerned.
No, your
We
lordship,
enjoy the position.
your lordship may see the position, my lord.
Yes.
Though the land vests with the government, possession continues to be with me, my lord. Your lordship may see the proviso, my lord. And utilized class 1 says, until and unless patta is granted, my lord, my possession is protected. Therefore, there cannot be any limitation, my lord, as far as these cases are concerned. And, my lord, it's after all a remand, my lord, to the commissioner, wherein, my lord, the commissioner's power has been reserved, my lord, under Section 7. Even, my lord, under the 714 GO, my lord, which has been relied on by the court, the power of the commissioner is saved, my lord, under the proviso, my lord. Your lordship may see the 714 GO, my lord.
Yes.
The power is not taken away, my lord.
Yes. Yes.
Therefore, remand, my lord, remand has been unnecessarily interfered, my lord, with the division bench.
Sorry, we don't think so. We are
No, my lord, the other side has not entered appearance.
No, they are there. You are there.
My lord, nobody has entered. Office note is there. My lord, this is a matter, my lord, where there was a...
Now, you can get Mr. Krishnamurthy, you can ask somebody. He says, it's a Tamil Nadu state. You serve the papers on him.
Yes, my lord.
Serve the papers. Then ASG director, AG director can take notice. Just get already. You will give a date option. Yes, February. Yes.
Very well.
Please, your lordship. Item 13, with your lordship's intervention, we have resolved the matter.
Yes.
The only thing is we'll just hand this over. Their clients are actually traveling overseas, so they need time and even we need time to execute the formal consent term.
Or they will adjourn it then.
Adjourn it for the date.
Milord, 15th of January, if it can be, Milord, they are back, Milord, in
15th
India.
of January, your lordship, because they are back from
Only for filing of the consent terms and...
Both the parties submitted that almost the issue disputes been resolved between the parties. Necessary documentation will be required to be done for the list in a general business.
And we are so obliged. It was only with your lordship's intervention
No, we appreciate
on the
that.
last date that we could speak to each other and resolve it. Much of that.
Around 15th.
Much obliged.
Item 14 is a bunch of matter, my lord. And I am praying some time to file the counter. As far as the first matter is concerned, it may be taken up separately because as far as the other matters are concerned, earlier these were remanded back. And upon remand, these have been decided.
All these matters are decided on remand, my lord.
No, my lord, the first matter is concerned, it is not my lord. The first matter, it's
Let him, sir. Yes.
All these matters are those Deepak Agarwal matters in which my lord decide the issue of initiation of the acquisition proceeding, my lord. My lords have remanded it back saying, my lord, that all the issues have to be decided. The Honorable High Court has not decided any of the issues, and my lord, that's why we are back. My lords have been keen to grant stay in a few matters, my lord. There is stay application in one of the matters and deletion application in one of the matters. They may file their counter in the meanwhile, my lord.
my lord, I will file the counter in all the matters, but kindly see the impugn order in the first matter.
Yes.
It says issue notification under section 6. As far as the other matters are concerned, that is not the situation. Therefore, I am saying it may be taken up altogether. I have no difficulty for it. All the matters may be taken up together. I have no problem for it. I will file.
Please don't say.
It is not a wrong statement. I don't know why he is saying.
Please, don't. They are not passing any order.
I will file the reply.
All right.
My lord,
4 weeks, my lord.
4 weeks back.
My lord, I am in item number 4.
Your date in non-miscellaneous day.
In 14.4, there is a stay application, my lord. They are demolishing the structure, my lord.
Yes, sir.
No, my lord, kindly see.
14.5, my lord, there is a deletion application for respondent number 5, my lord.
That's ordered, yes.
My
lord, I mean for 14.8, my lord.
My lord, as far as other matters are concerned, we have already taken possession.
Yes,
It is with us.
status quo as on today, that's all.
My lord. We'll see.
My lord, I am in item 14.8, my lord.
Yes.
My lord, I file an application for transposition of the parties, my lord. Application for transposition 14.8.
6 and 7.
Who has come in now?
Performer respondent number 6 and 7.
Transposition of party for what purpose?
Yes, my lord, because these petitioners are also in the High Court, in the writ petition in the High Court, my lord. And
We will take it up along with that when it comes next.
Please, my lord.
hello.
Yes. Yes. Yes.
Lord, what I have done,
Yes.
I have made a small compilation only on this question of express exclusion and implied exclusion.
But you have already argued that point.
No, I'm going to just rejoin, Lord. I've already argued. I'm just going to rejoin.
But Leonard, the Attorney General has to.
I think he had already responded on the last. I see. He wants to say something more.
The copy for me.
Let him complete his argument, then we'll come.
Very good.
What is that? Your compilation. Some further thought on what I.
Yes.
Should I?
Yes.
Before I just go to through this note.
Yes.
So now it's become a common legislative practice in special or local laws.
Yes.
To take over the whole subject of a limitation and provide for some limitation provision.
Yes.
I understand when the Limitation Act, both before and after 1963, when Section 29 itself has not undergone any change. It remains in the original.
We take it up after we complete the miscellaneous.
Very well.
Be better. All right. Oh, 16 now. Yes, 16.
Beg to appear for the respondent in the SLP, my lord, which was.
Item 16, my lord.
Yes.
Is a matter which has become complicated, my lord, going back to 1872, my lord.
I don't think so. Lord.
Lord, your
Take about half an hour to 45 minutes before your lordship.
Any SLP again, first of all, second appeal, we don't think it's complicated.
There's
Because
nothing
complication
complicated.
has been taken note of and considered in particular.
No, it's not. It's not first appeal, second appeal, my lord.
Yes, yes.
My lord, it is recall.
Yes.
This is an application, my lord, where a preliminary decree in partition suit is not touched.
Yes.
The final decree, my lord, has been set aside.
Yes.
Recalled.
Recalled.
Final decree has been set aside. And, my lord, the allegedly, my lord, on the ground that at the time of taking final decree, there was a fraud on the court. So, my lord, I'll have to take your lordship, my lord, in some detail through the judgment, my lord, because there is, first of all, no fraud. And secondly, my lord, this goes contrary to the principle that a third party, my lord, should not come into the suit and try to get his rights determined. So, my lord, it will take a little time, my lord, if your lordship, my lord.
Milord, this is one of those orders. This is the order, my lord, where?
We have no issue at all. If you have difficulty, we'll accommodate you, no problem.
No,
But
not,
we have no difficulty.
no, not difficulty, my lord. It will take some time because this is a matter which was allowed by this honorable court, and then on review, my lord, that order was recalled. So, my lord,
That's right.
Whether it would take considerable length of time or not,
yes,
depends upon your ability to make us to understand as you in tune with your thinking and our ability to follow your argument.
No, my lord, there is no question of your lordship's ability, my lord. But my lord, my ability to telescope it in, my lord, 10 minutes, my lord, will be difficult because it's my lord, gone on for a while, my lord,
Yes.
and therefore, my lord, the matter.
What do you say, bro? Already he seems having some difficulty today.
Milord, I would only pray for a date, Milord, this side of the vacation, if your lordship.
Not this side, not
Then this, Milord, there are.
Whether you are also there.
There's an intervention application on behalf of Milord Unity Small Finance Bank. We had lent about 100 crores also, Milord. Then intervention, we just want to be heard in this matter, Milord.
Milord, lordships may take a call on that when the SLP is being heard.
And that's correct.
If the SLP, if your lordships don't find any ground to interfere in the SLP, then the intervention goes.
We'll hear you along with that.
That's right. That's Milord, I would pray for a date.
We will give it on Wednesday or Thursday like this so that we can take
Very.
Yes, your lordship may do that.
do it in January sometime.
Grateful.
Yes.
7 of 58.
Sorry,
7 of 58.
You file it within
No, my lord,
2 weeks or 3 weeks.
State's right was considered and rejected by this honorable court earlier.
Yes.
State is a party, my lord, only for the sake of it. If they want to file it, let them file a counter. My lord.
We'll see about it. We'll see about
Lordships may
it.
fix a date in there.
This belongs to a particular category of litigation, my lord, which
7
your
of
lordships
58.
have seen repeatedly. The western side,
with 7 of 58.
yes,
Your lordships have.
Not this
the
one, not this one.
Not this one.
my lord,
Your
the
lordships have
western
dealt
side
with
of Hyderabad, my lord, which was, my lord, the Nizam's lands, my lord, and given to the Paigas, has, my lord, spawned litigation in a way that, my lord, very few areas of this country have.
Mr. Gupta will be able to telescope it in 10 minutes. There is no doubt.
The other matter we are hearing, Mr. Sinikolji, will have a bearing on that?
No, not this
No,
one.
the subject matter is different.
No.
Okay. Very well.
But incidentally, also a Paiga property. That's all the connection.
So that's me.
No, it's altogether different.
Yes.
This we are here because the order passed by the High Court, where under the suit was closed. I don't know how it would.
It was tagged along with this under orders of the Chief Justice. If your lordship
But
hear the
even
SLP,
that order is
if your lordship,
relevant for our case also, my lord.
that's fair enough, my lord. That's why they have been tagged along together.
No difficulty. They are, it's necessary to be heard together. No difficulty.
No.
Connected matters are also listed.
Yes.
There may be some other matters which are unconnected, which have got listed.
May take account, my lord. That
Yes,
cannot
no,
be a
no.
reason why
Which are not even relevant to this particular land.
that your lordship may take account of this.
2022 Millard was tagged with this. This is an order that was passed on 9 January 2025.
Very well, he will come.
Deeply obliged.
Your lordship notice 13 additions. Yes.
In 18 Milord interim protection, meanwhile, Milord.
What is that?
Milord, it's an anticipatory bail, essentially.
Anticipatory bail?
Yes, Milord.
And 302, how can you give anticipatory
Milord,
bail?
your lordships have
Not
granted.
bail application.
Milord, may I say something? Milord?
No, sorry.
Your lordship,
Argue.
two things I just want to say. Milord, can you pass it on? Your lordships have issued notice in a similar to the identical accused persons, Milord. In this FIR against this impugn order, Milord.
Charge sheet filed, is it?
No, charge sheet is not filed, Milord. These people are, Milord. The allegation is that they identical allegation, Milord. I'll read from FIR, Milord.
That is because of the ladies now.
Milord,
that is
Milord, may I read the FIR?
Lactating mother and then. No, but that is because they are women.
Milord,
see now and that is 437 itself gives leverage for separate treatment for women.
Milord, the second line may be seen, Milord. Second line is because there is a cross FIR. I filed by.
Sorry. We have heard.
Now, may I just say one
Please
thing?
argue matter.
Yes, Milord. Milord, may kindly come to page 25. Only two
Very
pages.
sorry, you made a statement that she is a lactating woman,
Yes,
19 years of age,
Yes.
and therefore we granted bail.
Yes,
So don't try to take advantage of that statement.
Milord,
No,
only-
very sorry.
Milord.
In fact, this deserves to be dismissed.
Yes.
Milord,
What
only
is this? No.
my lord,
No, this is the problem when some
Anticipate
relief is
bail,
given to
302 case, you keep showing an order.
No,
where
my
we
lord.
have
My lord, it may be a mistake on my part.
Very
Only 2 pages, my lord, may I show in this, my lord.
Yes.
These are family disputes, my lord. Page 25.
Death has not happened. Death has not happened.
My lord,
So family dispute, death has happened, you will give anticipated bail.
No, my lord, only 2 pages and then I leave it.
Yes.
So only
Yes.
2 small short portions, my lord. Page 25, my lord.
Yes, please.
Page 25, bottom, my lord.
Yes.
Then Lorik Bind alias Kamla Bind, Kunti Devi, Pankaj Kumar, Pradeep Kumar alias so-and-so, all these accused persons, from their rooftop on page 26, my lord, started hitting my son, who was lying in the lane by throwing bricks. So only allegation on me is that the main accused, who is not before your lordship today, my lord, main accused Pappu Bind pushed him from the roof, and accused on all of us is that we were throwing bricks, my lord. Now, my lord, kindly see the postmortem report. Only last thing, and I'll not say a word on that, my lord. My lord, page P2, sorry, annexure P2.
So main accused is absconding.
Main accused is absconding, my lord. I'm not seeking anticipatory bail for him, my lord. These people, my lord, page 28, my lord, may kindly be seen.
Yes.
Only one external injury is there, my lord, on page 30, my lord. This is the last page I'll show you, lordship, and then I'll bow down, my lord. Page 30 shows external examination, swelling present over dorsum of left hand cavity, so-and-so bleeding from left ear, my lord. No other external injury, my lord.
We have heard the counsel for the petitioner, we find no reason.
My lord, we are ready to present ourselves before the IO, my lord, in the next week.
We appreciate that.
2 people have been granted regular bail, my lord, in this.
We'll give regular bail. Come to us, we'll give regular bail.
Very well. Then, my lord, would like to give us some time to surrender, my lord. Maybe 6 weeks to surrender.
4 weeks to surrender.
4 weeks. Deeply obliged for the patient hearing. Deeply obliged. Grateful, my lord.
Yes.
Notice too much.
Notice. That's in addition.
Unfair.
Yes. Same one.
Item 21, I am appearing for the petition.
Item?
21, my lord.
We already issue notice, yes.
Yeah.
You are there, no? Take notice.
I am for the state, my lord.
CBI is respond number 2, my lord. They will have
MCOC.
That's in addition, yes.
What my appearance?
Yes. Yes.
My lords, in item 22, my lords, in a co-accused, my lords, lordship has already passed a certain order, if I am permitted to pass on, my lords. My
Yes,
apologies,
perhaps,
just have one, my lords. I'm sorry, my lords, only one copy I have.
No problem. Not for us, beauty. Tomorrow.
In view of this, my lords, because your lordship and earlier co-accused. Lordship, no, my submission is this, my lords. Lordship had directed that all the applications now should be heard within 6 weeks. The matter is listed today. My only prayer is Lordship may have this matter after 6 weeks. So at least, my Lordship, that gets...
Sorry,
but this will become infructuous, my lords, otherwise. That's it. Then same order, my lords, would just...
Same order.
Lordship.
I came against the rejection of 311 application.
You should impose an exemplary cost.
My lord, what I'm saying.
Stage you are putting.
My lord, what I'm saying is some documents we may be taken on record. Just the only prayer. I'm not saying examine me.
We have heard the counsel. We have no reason.
Lordship, the cross may be exempted. Lordship, he's old age person, around 72 years, and the complainant is his son. My lord, this is the cost be exempted. Just
Cost, how much is the cost?
High Court has imposed the cost. High Court has imposed the cost of 30,000.
30,000 only.
Yeah.
Complaint is your son.
Yes, ma'am. This is the
taking out of the fact the complaint is the son of the petitioner. The cost imposed is made easy. Yes.
Much.
Please, your lordships have seen that I have not been a part. I've not been heard by the High Court. Your lordships categorically said go and file a review.
Yes.
The impugned order notices that I was not even heard. And kindly see what the High Court has to say.
That's right. The High Court says that the order gives you an opportunity. You will also be given an opportunity.
That order got already rejected before the High Court passed that order. That's what was not being noticed by the High Court. Would your lordship kindly come to
challenge that order?
Yeah, please see that.
See now, High Court says
yes.
The grievance has been redressed by complete to give an opportunity of hearing and decide the technical qualification by recent order.
That was there earlier, Lord, which is against which we came in appeal here, Lord. Your lordship said that order has not been, we were not heard in the High Court. What the High Court in the impugned order again says now that there is no change that must make. Please see 291, Lord.
Yes.
Already rejected even before the impugned order is passed. I have to be heard.
Yes, we are not inclined to interpret the order passed review application. However, the order passed by the tender committee is
yes, not 291, 292. Not
rejecting the case of the petitioner.
292.
Yes, can very well be challenged.
Would your lordship kindly give me an opportunity, my lord.
You have given the opportunity before us, that's all.
Let nothing proceed in the meantime. Give me 2 weeks time, I'll go and challenge
Man,
it.
known to law, now order has passed with us, yes, that's all.
Very well.
May it please your lordship.
Yes.
Well, this is a case, my lords, where the victim, my lords, was in police custody, admittedly illegal custody, my lords, illegal police custody from, my lords, 28/5/2015, admitted to hospital on 5/6, succumbed on 6/6. My lords, what the trial court rightly, sessions court rightly does is, it frames a charge under 302, which has been converted into 304 part 2. Lordship may kindly look at the post-mortem report, my lord, the injuries and the weapons that have been used. What is the most brutal thing in the sense, in the counter of the...
Nails have been removed.
My lord, the 2 nails have been removed, hands, and you lordship may look at the counter. What they do is, they place this man against a wall with his face back facing them, use rods, use lattice, and thereafter, my lords, there is a doctor who clearly tells them that the condition is critical, you need to take him to the hospital. Instead of asking and taking him to the hospital, they bring him back to the station, and in the garage behind the station, they again inflict injuries. And after 4 days, my lords, at that, when there is absolutely no chance of any recovery, they take him to the police station. And where is the, my lord, what is so overwhelming to convert the charge of 302 to 304 part 2, my lord?
Yes, it's very simple.
Yes, learned counsel.
And my lords, only one, just 2 minutes, my lords. Your lordship may kindly look at the counter, my lords, just for a second.
Yes.
Because that clearly throws the light as what happened in the police station. Your lordship may kindly
counter of the
respondent number 2. At page 6, my lord, state. The state counter, my lords.
Yes. Yes.
Page 6. Lordship may kindly. Page 6. This is the state itself is supporting the case right from the beginning. Your lordship may kindly look at 6, my lords. Your lordship got 6 of R2. Yes.
Yes.
From page at top, my lords.
Yes.
A1 kept Subramani close to the wall and made him to stand facing the wall, and A2 and A3 held Subramani close to the wall, and by using Lati, A1 repeatedly had beaten Subramani over the back, upper thigh, knee, shoulder and elbow. Then after allowing him a while to walk for some time, A1 made Subramani to sit leaning his back on the wall and stretching his legs, keeping both legs closely. Then again, while holding Subramani, A2 and A3 repeatedly had beaten Subramani on the sole using Lati, which was seen by witness Elizabeth. And my lord, this is also a case, my lords, where when the first was caught, my lords, I should not say this, I don't want to read that in the open court. 3-year-old girl, 4-year-old girl, without proper dress, my lords, they take her also to the police station along with the father. Lordship, this is a very, very serious.
If this is not a murder, then we'll have to request the parliament to amend the definition.
Absolutely, my lords. Absolutely.
If this is not the murder.
And ultimately, my lords, if they fall under an exception, 302, they can always, court can commit for a lesser offense. But if you put him under 304 straight away.
He heard you.
My lord, beg to appear for the second accused. Lord, I've submitted my paper book for the A2. My paper book.
Yes.
There are 2 circumstances.
Yes.
One is, my lord.
Yes, the city council has come, allow him to argue. See, obviously, you don't know whether he on purpose is coming late or he is getting other court.
Madam, my item is 13
Yes, tell us what is it.
in the first court. Madam, my humble submission in this matter would be, my lords. There are 2 views. One set of doctors say, my lord, it is natural death. Other doctors.
Natural death?
No.
Natural.
How do you explain the injuries?
My lords, that's what I am saying. Madam.
Self-inflicted.
No, I'm not asking for quashing.
No, self-inflicted injuries.
No, that is my defense, which I may take during trial.
That is your defense, that's self-inflicted.
That I may take.
A man beaten to death.
I cannot be.
A man beaten to death.
Yes.
I mean, he was beaten brutally.
How can you?
If this is not a murder, what else will amount to murder?
My humble submission.
No.
No, my humble submission would be, madam. Kindly permit me. If you are going to say that it is a clear case of murder, then what remains for me, to defend?
See,
nothing.
See,
so therefore,
we
my
are
humble.
not on that. We are on
my defense.
302 to 304.
You also will appreciate me. My defense tomorrow, I may say that even it is a suicide. It is my right to take such a defense. So therefore, my defense cannot be disclosed.
Take your defense.
My defense cannot be disclosed at this stage. So now what I am submitting is very simple. My kindly concern from where there are 3 medical opinions. Some opinions say that it was due to acute renal failure. It is a natural cause. some witnesses say. On that score, my lord, I filed a petition saying that for injuries
We
caused.
have heard you. We see, you are right in saying that we'll not give a finding that is 302. But
Charge would be.
I personally, I need not tell you how charges should be framed, because this is what says something you very near to your own personal heart. I am telling you, whether it come under part 1, part 2, or 302, even I need not tell you, and you are too well versed in this. Now, if you say something more, then we will say it's a case of 302. And
we are not saying anything. But what I am submitting, that is what I am trying to say.
That's what we are saying. That's a better way of putting it.
What I am
nothing beyond.
What I
if
am.
you argue, say one word more, then we will say that it is.
Lordship may not take it as Lordship may not take it as an argument.
Yes.
Lordship may not take it as argument. What I am only suggesting is this. Lordship kindly consider this. There are two views. One view, if taken into account, it will be 302. If the other opinion is taken,
we are not saying anything. We are not saying anything on this.
My request is very small. My request would be the trial court may alternatively frame charge in a 304.
No.
Also, alternatively.
That also we are rejecting. Take them. Leave granted.
Then you may not express any view.
We are trying to give you some relief that we thought of you telling this. You know, see, you have been a trial lawyer of repute. And then if we expect you to argue on this, then it's very unfortunate. That's what we are saying. This is what we are telling you. Try to mitigate it. It's fine. We appreciate that.
I already said that I am not arguing.
Then we'll have to go into it.
You already said that I am not arguing. You may not take it as an argument. It is only with suggestion which I submitted.
Yes, sir.
It only with suggestion.
Granted.
Great from us.
It's an unfortunate case. We have heard the cynicals appearing for the parties. It's an unfortunate case where the High Court has conducted a mini trial, ignoring the materials available for the charges framed. Though arguments have been made on merit, we desist ourselves prompting us to go into it. We desist from doing so only for the reason that any observation made would hamper the trial. Suffice it is to state that it's a fit case where the High Court, where High Court has completely committed an error in reversing the well-merited finding of the trial court in bringing the charge and 304 part 2. So such was the matter. The inquiry orders and set aside, leaving all the issues were open. The trial court shall proceed with the charge as framed for the offense punishment of section 302.
The charges have to be framed.
No,
It has to be framed.
It has been framed already.
Charges have to be framed.
Frame. Charges are
influenced by any of these. Let it not give an indication to the court.
That the trial court shall conclude the trial and deliver the judgment without being influenced by any of the observation that either to the High Court or by the parties.
only one request. Expedite 2015 charge. Lakshmi expedite the trial. Otherwise,
The trial court is actually expedite the trial.
very obliged.
So only one thing that I got, but because your lordship is not allowing me to argue, I am not arguing not on the point. Which court is to try? Now my case before the SC/ST court. How SC/ST court can hold jurisdiction in the matter? Trial is to be held by the session court.
We are not concerned in that.
There is no charge.
More password is there? No.
Your Lordships, item 20 was called out, but the arguing counsel was not unmuted. She was connected online.
Item 20, we already issued notice. We issued notice, that's in addition, permitted to standing counsel.
I'm obliged, Lordships.
Yes, please. Yes. Yeah. Yes. Give me a stapler.
I'm not responsible. As you will. If you look into section 29 of the Limitation Act, I was trying to say that this provision has remained the same throughout.
Yes.
And if there is any importance of looking at section 29 before any special or a local law
Yes.
undertakes the subject of prescribing a limitation period other than what is enacted under the schedule. I think there is something to be said about that.
Yes.
Therefore, when section 29 says by express exclusion, sections 4 to 24 to be excluded, it has to be by express exclusion. Even though in some authority, the lords have said there can be an implied exclusion, but I think that may or may not be a correct way of looking at it, because every provision from 4 to 24 have, as I point out my note, have a significant relevance for the ultimate determination of the period of limitation. The court is closed, somebody suffers a disability,
Yes.
going to a wrong court.
Yes.
So each and every one of those provisions from 4 to 24
Yes.
have importance for what I may call the ultimate determination of limitation. So if a special or a local law has not paid sufficient attention to express exclusion and non-advertence to any one of the provisions may have a serious consequence, and the court may say in the absence of an express exclusion, sections 4 to 24 would apply.
That's correct.
But then we have now, as I said, the common legislative practice that were what I may call a primary period of limitation and a secondary period of limitation.
Yes.
The Limitation Act in the schedule has only one period of limitation.
Yes.
Section 25 brings about what I may call a secondary period where an open-ended condemnation of delay is available to an applicant or a person who is an appeal. Therefore, if I call it a primary period of limitation and a secondary period of limitation, which all special or local laws now resort to. So the secondary period of limitation is ordinarily inserted by way of proviso. So in a substantive period of a primary period of limitation in the substantive provision, the proviso will now say, borrowing what is called the principles of section 5, we will have another period of limitation for you, secondary period, but you must come within that period. The condemnation principle of the philosophy in section 5 will not be, given beyond what is noted in the secondary period. But if in a given set of circumstances, there are legislation, Your Lordship, please. Your Lordship. No, if my note has triggered, if it has triggered a discussion, I hope it's a healthy triggering.
Sometimes after a matter is over, also it lingers in our mind.
Of course.
So,
And then if council can make that happen, then we are happy.
yes.
Now, I was trying to say that we look at the legislation depending upon the nature and the purpose of the. And that's what I put in my note, but let me put it orally. I went through the 2013 Act all over again, and then maybe it's worth going back to 24(1)(a) and again. And so broadly on my understanding of this legislation, since if the proceeding relating to prosecution of matters, namely whether a reference to an authority or an appeal to the High Court, if those procedures are not contemplated to be applicable in the context section 24(1)(a), then in the facts of this case from Karnataka, I don't think section 74 would be attracted at all. Insofar as section 74 would be attracted, I think only if you go out of section 24(1)(a) and 1(b. Kindly come back to 24(1)(b) because I also find under section 24(2), may I just read section 24(2) first and then to 1(a) and b later.
Just a minute. How much time will be required?
Another half an hour or so.
How much time you all would do?
Lords, about 20 minutes in rejoinder, my lord. 25 minutes.
10 minutes.
Like 10 minutes.
I'm being led by Mr. Vikas Singh Malins. We'll also require about 15 minutes.
15 minutes. Sit at all that half an hour. After I take we'll take it. You finish it up, all of you put together.
We'll definitely try to finish it up.
No problem. We spill no problem. We really trying to tell you that other lawyers need not.
Please.
So we don't want them to.
Please.
The others can come and check up after lunch. After lunch also, we have one more important matters there. But please come and check up after lunch. The other matters, yes.
Great.
Where is it?
Yes, your lordship. I think it's tomorrow.
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 You please better be ready.
Yes.
No, sir is there because.
He's always ready, my lord.
No, I feel sorry. I feel really sorry for it. The amount of hard work he has put in.
Yeah.
And without charging a single penny.
I know I've been appearing in the Nepali matter, but before Justice Arun Mishra matter was going on for a long time.
He was one of the early birds in that matter, assisting the court.
He is to be blamed.
Yes,
Section 24(2).
Yes,
Notwithstanding anything contained in subsection 1, in case of land acquisition proceedings initiated under the 2013 Act.
I have marked it, just take that slide. It will be here, in this one, marked by. Marked. Take the Limitation Act, and the 24 both. I think it must be in the other code, no?
Must be in code 6.
Okay.
Just get that and replace.
Must be in code 6.
Yes. Both the Limitation Act and then. Yes, please go ahead.
I invite your lord's attention to subsection 2 of section 24 of the 2013 Act.
Yes. Yes, please.
I just look at the legislative intent here. It says, notwithstanding anything contained in subsection 1 in case of land acquisition proceeding to initiate under the Land Acquisition Act so and so, where an award has been made 5 years or more.
Yes.
5 years or more prior to the commencement of the Act. So something which has become stale. But the physical possession of the land has not been taken or the compensation has not been paid, the said proceeding shall be deemed to have lapsed, the entirety of them. And the appropriate government shall initiate proceedings at so and so, afresh in accordance with the provisions of this Act. So the legislature thought something must be started all over again, they've said so in very clear terms. They were very, something just carved out for that particular purpose. Unlike that, and then see also the proviso. Provided that where an award has been made and a compensation respect, the majority of land holdings has not been deposited in the account of the beneficiary, then the beneficiary specified in notification acquisition so and so shall be entitled to compensation in accordance with the provisions of this Act. Therefore, while they say it will now happen under this new Act, if there's another small class of set of actions they're taken out of the subsection 2, but they will be entitled to compensation under this Act. It does not say proceedings shall be undertaken under this Act. So a subsection 2 is a complete departure from 24(1)(a)(b), and the proviso is probably would fall into the class of 1(a) and B. Now, I also find there is a Tamil Nadu amendment, if lots of probably in the barrack, the bottom of that.
Yes.
There is a state amendment. Lord, have that?
Yes.
You say in section 24, in subsection 2, after the proviso, add the following proviso and explanation, namely, provided further that nothing contained in the subsection shall apply in case of land acquisition proceeding initiated in the Land Acquisition Act 1894, where the land acquisition disposition is under litigation before the court as on the date of so-and-so, or where the landowner has not made a claim for compensation or has not claimed the compensation amount as on so-and-so.
This is more of a clarificatory.
Therefore, when there is a possibility of something which may happen outside the contemplation of this provision, the state says, look here, I know what's happening in my state. Therefore, I need to take care of that. For this proviso, this substitution in subsection 1 and 2 proviso are important indicators so that in case of land acquisition, when you have a transition, there could be any number of problems which the legislature probably would not have adverted to or taken notice of. So then we now go to 24(1)(a), having read 24(2). So 24(1)(a) certainly says, I keep 24(1)(a) and the proviso to subsection 2 in juxtaposition. So if 24(1)(a) says provisions relating to the determination of compensation shall apply, please keep that in mind. And in the proviso to subsection 2 also they says they'll be entitled to compensation according to the provisions of the Act. Therefore, they convey the same intent. Legislative intent is common.
Yes.
So to the extent the compensation can be determined under this Act,
Yes.
as against the old Act, they will be so determined. And after such...
That other actual land action.